For pronouncement of judgment, item 13.
Writ appeal stands allowed. Consequently, the writ petition and the non-writ single judge's order stands. Possible.
Adjournment request, if any, from item number 1 to 7.
May I please, Your Lordship, my lord. I beg to mention item number 7, my lord. May this matter be taken up on next week, my lord. Item 7.
Will go in September. September.
Your Lordship. My lord, in item number 3,
At the request of land council, the other party, adjournment slip was circulated with no objection from the other party.
my lord, in item number 3, we have filed an additional affidavit today that may be allowed to be brought on record.
Mangala.
All this.
May I please, Lordship, item number 6.
6. Adjourn.
From item number 8 to 12.
We adjourn.
May I please, Your Lordship, my lord, item number 11, my lord, we are filing an affidavit today, my lord. This may also be taken up next week.
Why next week? Aji Mangala.
My lord,
We'll ask for the affidavit today itself.
my lord, then Friday, my lord. Actually, my senior is also out of station. Friday, my lord.
And it will go in August. So,
Oblige.
May it please, Your Lordship, with the concern of the others, I beg to mention item number 12, Your Lordship.
adjourn.
Oblige.
Any other request?
May it please your lordship. Lordship, I'm really sorry for troubling lordship. Actually, it's a rare situation, lordship. A writ appeal that was fixed tomorrow, your lordship, that is 7th, your lordship. And there is some urgency because, lordship, there is no stay. Last week came up for, it's a Mizoram matter.
Tomorrow is we have declared the holiday. It will.
Yes, lordship. But kindly I request, lordship, can it be fixed on 8th, your lordship? There is some urgency, your lordship.
You ask the registry, they will do. No,
Lordship, actually, the daily list is already out, your lordship.
whatever it may, ask the.
Much obliged, lordship.
Yes.
Daily list. Sorry. Supplementary list, item 14.
Your Lordship, I am sorry for yesterday's that I could not able to.
Yes. We already taken the steps.
My lord.
We already taken the steps under section 14.
Yes, order has been given, only execution part is pending.
The execution part, they'll execute it.
Yes, sir.
Once
The
they have
time bound period will be given.
already appointed officer for supervising,
Yes, sir.
this petition is filed by the petitioners seeking a prayer. That the respondents, the respondent number 2 be directed be directed to act as per the order dated 21/3/2024 passed under section 14 of the Sulphate Act 2002. The Senate Council for the State has submitted that the respondent, that the additional district commissioner, a district magistrate shall take necessary action pursuant to the order dated 21/3/2024 within a period of
10 days.
within a period of 10 days in view of the assurance given by the concept for the respondent. This writ petition is disposed of with the expectation that the respondent number 2 shall take appropriate steps in accordance with law within a period of 2 weeks from today, 10 days from today.
Daily list for hearing, item 1 and 2. Sorry.
See, with respect to item number one, I may plead that may be taken some other day. Because I'm watching for since morning.
Mr. KL, and council appearing for the applicant, the appellant,
No, responding.
the respondents praise some time to argue the matter. List up the list in the month of September. Other party has no objection. If the adjournment is granted, list in the month of September.
See, with respect to item number two,
Obliged,
the same issue is pending before Honorable Supreme Court.
Still, and a council for the parties have submitted that the issue involved in this petition is pending before the Honorable Supreme Court. So the matter may be adjourned. In view of the submissions made by the council for the parties, we deem it appropriate to adjourn the appeal, sine die, with liberty to the either of the parties to move appropriate application after the similar issue is decided by the Honorable Supreme Court.
Much obliged. Item 3 and 4.
My lord, on the last occasion, your worship,
Give us the copy of the affidavit. After your affidavit, today you have filed the affidavit, copy of that.
my lord, copy is yet to come, my lord, can it be after?
Receive the copy. I also not received the copy.
Mana copy ako? Ano ba, surulit ka na yung
Will take after some time, let the.
Right.
Bengali.
Item number 5.
May I please, your lordship? Your lordship, may we first peruse the order of this report, lordships. 28/4/2023. Very task of the matter that has been reflected in this order, lordship. 28/4/2023. Then next order 26/7/2023.
Just a minute.
Then the was only 15. It was cancelled on 10/4. On a single. Okay. This one, another thing is only 1050 prescription that is notification of. It's not because people use it. It's everyone of public. Then they are given not to any. That was not. That is the only reason there is.
Is for the state.
When the order dated 7 and the order dated 20. They're being paid.
That's another thing. Who is for the state to argue on the matter? This is for the hearing, madam. What is the stand of the state government?
Just number 3 filed affidavit, page 130, Lordship. Paragraph 3 and 5, 3 stated, you have 10, Lordship.
Paragraph 3 on the page 130.
Advertisement is 29. Advertisement. And selection was we go to 20 to 2. We which not important.
Yes, who is for the state? And who is for the private respondent? You are for the private respondent here.
My lord, briefly, there was a notification which had introduced certain advanced criteria for selection of Gaupura. That notification, my lord, was kept in abeyance on 2007.
The notification was issued when?
5/1/2016, my lord.
Okay,
It was kept in abeyance from 2017.
right.
And the new notification, my lord, again with advanced criteria, your lordship, were introduced on 10/4/2018. Now, the selection of the appellant, my lord, which was challenged by the respondent in the writ petition, had taken place during the period in which the notification was in abeyance. Now, the issue that fell before the Honorable Single Judge, my lord, was whether the word abeyance would mean a temporary suspension of the criteria which were introduced, or would it mean reversion back to the earlier criteria where there were no advanced criteria which are laid down by the state. My lord, in this regard, if your lordship can kindly come to page 67 of the writ petition. Writ appeal, my lord. Sorry. This is dated 5th of January 2016, where the minimum qualification, the executive
Matriculation. Matriculation was the.
matriculation was included, my lord. Thereafter,
So now the question is,
yes,
which criteria, whether the authority who selected the appellant
yes,
has rightly selected him, taking
Since-
into consideration the fact that this criteria by the notification, given by the notification 5/1/2016 is kept in abeyance,
Yes.
and therefore
yes,
the earlier
that is the-
criteria is to be followed.
that is their submission.
That is their submission. Learned Single Judge has said that though it was kept in abeyance, but it
Yes.
was not wiped out, and
Yes,
therefore it has to be followed by that.
yes, that was the stand which was taken by the learned single judge. Now, your lordship will kindly come to page 150, which is where the notification has been kept in abeyance. 150, 150, my lord.
Yeah,
Kindly refer to the government notification dated so and so regarding new guidelines on selection and appointment of Gaupura. You're hereby directed not to act on the said notification, and the operation of the said notification may be kept in abeyance until further order. Now, my first leg of my submission, my lord, is that when the new notifications were introduced, the new notification, my lord, is at page 34. Page 34. The new notification refers back to the notification dated 6/1/2016, which primarily means, my lord, subject to correction, that till 10th of April 2018, the notification of 6/1/2016 was in force, although it could not have been implemented since it was kept in abeyance. my lord.
suppose tomorrow,
Yes, madam.
relying on this notification 6/1/2016,
Yes.
even if it was kept in abeyance, if some selections were conducted pursuant to these guidelines, what about those selections?
Your lordship, what had transpired in the earlier set of litigation, I'll come back to
Even
yes.
though it was
Yes.
kept in abeyance, but
Yes.
if the selections were made following these instructions or guidelines or whatever it may be, notification 6/1/2016,
Yes,
those selections were good.
those selections were good, provided
Think
Yes.
vice versa then.
yes, because there's certain peculiarity in the writ petitions here, my lord.
Ah.
The reason being, the first writ petition, which was disposed of on 31/5/2017, there was a submission made by the state, rightly or wrongly, you are not going to that, Your Lordship,
Yes.
that new improved guidelines had come into play.
Right.
And this honorable court,
Without
pursuant to
disclosing this, that it was
pursuant to
kept
the
in
submission,
abeyance.
yes. Now, my lord, will kindly look into the advertisement. The advertisement, my lord, is at page 30. If I may read, my lord.
Yes.
My lord, page 30 is the advertisement.
Yes.
My lord, page 30
Yeah.
is the advertisement.
Yes.
As per the letter number so and so dated so and so of the Honorable Guwahati High Court, issued in terms of the order dated 31/5/2017, passed by the Honorable Guwahati High Court in WPC number 4289 of 2015. And as per letter number so and so, it is hereby informed to the local people that applications are invited from intending candidates for the vacant post of Gaupura at charge number 17 of Borpeta, Moza in the district of Borpeta under Borpeta Revenue Circle. I'll pause here for a moment, my lord. This advertisement, which has been assailed in this in the writ appeal, has flown from the directions of the learned single judge, right or wrong, your lordship, that I'm not going into. The learned single judge very categorically observed that there were improved guidelines which are holding the field, right or wrong. Again, that was not also gone into review by the state. That order had attained some sort of finality before this honorable court I'm submitting, my lord. And pursuant to the direction of the honorable single judge, the advertisement had flown. Now for us to compare the terms of the advertisement as against the regulations which are holding the field at that point in time, my lord, may not go into that aspect. the fact, I'm on a very thin line here because the word abeyance, does it mean recall to the particular state or it means a suspended state?
Not,
Now, I've gone,
certainly not recalling or wiping out.
I've gone into, I've
The
tried,
order is still there, but its operation was still.
the operation was, and that ought to have been pointed out. At that time, there was probably a lapse from the government where it was, but again, rightly or wrongly, that advertisement flowed from the words
The
of the
fact
Honorable
remains
Single Judge.
that despite though the
Yes.
court has given a direction, but the fact remains that it was kept in abeyance prior
Yes.
to that.
Yes, it was
31
kept in abeyance, yes,
31/5/2017, it was kept in abeyance in February.
in February. Now, my lord, the point is when I go into the authorities on the word abeyance, I find very few instances, one of it being SG Bombatkere versus Union of India, where section 124A of the IPC had been kept in abeyance. Now I ask myself whether section 124A is operative at this point in time or not. The answer is no.
Yeah.
But do we mean that we have repealed that section? That again, the answer would be no. Now, my lord, the fact of the matter remains that there were notifications which were introduced in 2016, and for a bare minimum period of time, when the selection happened incidentally or coincidentally, that should not take away the entire import and purpose of the notification of 2016, which was further
Certainly.
substantiated, my lord, by 2018.
Another question, the
Yes.
opposite question is,
Yes, ma'am.
suppose tomorrow, if after following, despite this, keeping the notification, issuing guidelines was kept in abeyance, if certain selections could have made on the basis of those notifications, what about those selections? Whether those selections are good or bad?
In fact, those selections, my lord, that happened in a vacuum where there were no regulations holding the field. That will be my submission
Then
before
what
this
would be
honorable
the
court.
position?
The position ought to have been that the state would have given them effect from a prospective date when the new notifications have come into play. If there is a way to look at it, my lord, because there is a vacuum which is created where there is no guideline governing the situation, and my lord will see in 2016 and 2018, two improved guidelines were taken into. I have no grievance against that education qualification to the appellant, but the fact remains.
No, there is no doubt about
Yes,
that.
but in
He
2016,
is not matriculate.
yes,
This
he's
is
not
admitted
matriculate, that these are admitted facts, and for a bare minimum period of time, which was a vacuum at that point in time, should not defeat the important
Around more
purpose.
than 1 year. Short
Yes,
period,
yes,
not
yes.
more than 1 year, from
Yes.
February to April.
Yes, but in fact, if the lordship will also see that the subsequent notification which came had not whittled down the earlier notification 2016, rather it had amplified the entire import of that. Now, for something to have happened in that vacuum where there were no regulations, my lord, my humble submission that will completely defeat the entire import and the intent of 2016 notification as well as 2018 notification.
2016 notification was kept in abeyance, so there is no purport of that.
Yes, yes. So that is my limited submission in the matter, my lord. And the fact is that the honorable court may not go into the aspects of interpreting the clauses of the advertisement, since the advertisement had flown from the order of the learned single judge, right or wrong. That is my submission.
Where is the learned single judge order?
Yes, my lord. The learned single judge's order is 31/5. My lord, it is at page 105. 105, my lord. The operative portion starts at 107.
Just
Yes. Starts at 105. Oh, I can take it.
yes.
Yes, my lord. Page 107, paragraph number 5, if I may be permitted to read, my lord.
Yes.
It appears that the works of charge number 17 is being managed on an ad hoc basis through the Gaupura of the charge number 7, and this is certainly hampering the works in charge number 17, where a regular Gaupura has not been appointed. It further appears that recent executive instruction was issued on 6/1/2016 for selection and appointment of Gaupuras. And since the earlier advertisement issued on 6/8/2014 has not led to appointment of a regular person, I am of the considered view that authorities should initiate a fresh process of recruitment for charge number 17 by abandoning its earlier process initiated through the advertisement of 6/8/2014. This is considered necessary as fresh eligibility norms are prescribed recently to ensure appointment of better merited person. This order had attained finality, my lord. This order was not gone into in review. And pursuant to this order, had the advertisement of 31/5/2017.
And now read para number 6.
Yes. Consequently, the DC Borpeta is directed to take fresh necessary steps in accordance with the current norms for selection of the Gaupura for
Which are
charge
the
number.
current norms?
Current norms. There were no current norms at that point in time. Neither 2016 nor prior to that. So it is a vacuum which was posed before this honorable court. And combining and reading paragraph number 5 and paragraph number 6 together, my lord, it is my humble submission before this court that there are better advanced criteria which are laid down, which ought to have been followed. If nothing at all, the selection process should have been kept in abeyance also. But that was not being done. That particular stretch of time should not deny a better merited person to have held on to the charge of Gaupura, which was prescribed by 2016 and 18.
At present, this guidelines dated 10/4/2018
18.
are in current.
Yes, my lord. Yes, my lord. Subject to correction from my senior friend from the yes, they're in.
Yes. Counsel for the state, what is your stand?
It was when the active, they say that this was withdrawn, my lord, the 2016 set of guidelines, they were withdrawn. There was no set of rules in force at that time. And it came to be
So
pointed
if
in,
there was no set of rules,
yes, ma'am.
then what about the selection of this appellant as Gaupura?
The affidavit says, my lord, clause 162 of the executive instructions, which did not set the 10th standard.
So you're defending this.
That's, I sink or swim with it.
Those for orders.
Like,
Mobilize.
If I may furnish 2 copies of judgment pertaining to not like.
Item 8.
May it please your lordship. But certain tender conditions were put to challenge, madam. So now this situation is like this, one of the, there is no interim order operating. So the private respondent has proceeded with the work. So at this stage, my lord, I may not get any relief as against the private, quasi-private respondent, my lord. But if the terms and conditions remain, my lord, I will never be able to participate in a similar tender.
Whenever the occasion arises, file a fresh petition.
Lordship will have to give me that liberty, my lord.
It's always there.
Because no, my lord, because the judgment has categorically held that these are not restrictive clauses.
Then argue it out.
My lord, then I'll argue.
Argue it out.
My lord, the facts are like this, my lord. On 24/1/2024, an NIT was issued, my lord. There also similar clauses existed. We filed a representation.
24.
24/1/2024.
Yes.
We filed a representation, my lord. That tender was withdrawn. Fresh NIT was issued on 15/2/24.
This was withdrawn when?
This was withdrawn, my lord. There's no order as such, my lord, but the fresh notification is issued on 15/2/24. That NIT starts at page 76, my lord. Now, if your lordship kindly
Fresh notification 16.
15/2/24.
2024. Yes,
Now, if your lordship kindly turns to page 77, my lord.
yes,
In the middle portion, lordship will find a table, my lord.
yeah,
The estimated cost of the work is 1 crore 50 lakhs 34,000 and odd. Lordship turns to page 78. The total manpower required is given, my lord. The total comes to 154. This is again elaborated in page 79, clause 2A.
yes,
Now, lordship, I'll take lordship back to page 78. my lord. Now, this is a manpower-based contract. my lord. I am required to provide security services. I am required to pay them the minimum wages, my lord. And over and above the minimum wages, my lord, I'll be entitled to a service charge.
that's a condition.
So this is the crux, my lord. Because the tender itself says that I have to quote my rates of service charge within a particular range, my lord. 3.85 to 7%. 3.85 is the minimum, 7 is the maximum. So no one will quote above 3.85, my lord. Everyone will quote the minimum. That is what has happened, my lord. Now, lordship will kindly turn to the marking criteria at page 86. Because the tender provides that when the price bid is the same, then whoever secures more marks will get the contract. So the marks obtained in the technical evaluation, my lord, that is the deciding factor. I take your lordships to page 86, my lord. Point number 1, my lord. Similar experience in government, state government, department, so and so, so and so. Maximum is 20 marks. Lordship has got it, my lord. Point A, executed single contract value up to 10 crores is 10 marks and more than 10 crores is 20 marks. So where the value of the work is 1.5 crores, my lord, the half of the marks is given up to 10 crores. Well, there is a CVC guidelines, my lord, of the Central Vigilance Commission that when you are how to fix the minimum eligibility criteria, certain percentages of given, my lord. I'll take your lordships to that. Similarly, my lord, point number 3. Annual, because 2 is the number of works experience, my lord, I'm not going into that. 3, my lord, annual turnover of the company of any of the last 3 years up to 100 crores. So if you are having a turnover of 1 lakh or 99 crores, you get the same marks. Above 100 crores, you get double the mark. So as a result of this criteria, similarly, at manpower is also 5,000 is the minimum. I won't say minimum, the use of the word minimum will be wrong, my lord. But 5,000, requirement is 150. But the criteria is you get half of the marks allotted if you have 5,000 workmen.
Up to.
Up to. So as
So
a
if a person is
exactly,
having
ma'am.
200 or if a person is having 4,900.
Yes,
he'll
he'll
also
get
the same mark.
As a result, what has happened, my lord, no one in the state of Assam will secure more than 32 marks in this, my lord. What I am on is, my lord, what you could not do directly, you have sought to do it indirectly. You have eliminated everyone. This is how my respect for submission, my lord, that it is a restrictive clause. I have specifically stated in the additional affidavit that none of the petitioner is a society, my lord. It's an association. None of the petitioners, members of the association will secure more than 32. And the minimum eligibility.
These are the only persons in the state of Assam who are providing these security services, or members of the association or
Members of the association. These are the
only.
Yes, everyone is there, my lord.
Otherwise, no other agency.
No other agencies, because here both the parties are from outside Assam, my lord. The eligible parties.
Whatever it may be, they can't restrict on the basis of this state. Okay, since you are from this state, only those persons.
No, I'm not on that, my lord. I'm not on that. There cannot be a restriction so far as place of business is concerned. Anyone can come, my lord. But a small party
who is having, suppose requirement is 150, my lord.
Ultimately, now it is well recognized or well settled.
Absolutely
by
with
the
your lordship, my lord.
Supreme Court in various judgments that they are the best judge of their
Absolutely, absolutely.
needs, and they can have the conditions as which are suiting them,
Absolutely, my lord. Absolutely. But
which
if,
suits
if,
them.
but if it is tailor-made to suit someone, my lord, then lordships will interfere.
Which one, sir?
These parties,
These parties.
only two eligible bidders, my lord.
Sir, even though only these, as per this, only 2 bidders are eligible, otherwise not in all of India, no other bidder was eligible.
All of India, there will be, my lord. But from the state of Assam, none, my lord. And the requirement is,
Yes,
only 2 documents I'll take your lordships to, my lord. The CVC guidelines at page 99, my lord.
yes,
This is an office memorandum of 2002, my lord.
Yeah.
Point number 3.
yeah.
Some of the common irregularities, lapses observed in this regard are highlighted as under. These are certain instances now. For a work with an estimated cost of 15 crores to be completed in 2 years, the criteria for average turnover in the last 5 years was kept at 15 crores. Although the amount of work to be executed in 1 year was only 7.5 crores. The above resulted in pre-qualification of a single firm. Point number 2 is very important, my lord. One organization for purchase of computers hardware kept in criteria for financial annual turnover of 100 crores, although the value of the purchase was less than rupees 10 crores, resulting in disqualification of reputed computer firms. I am on this, my lord. And there is a CPWD guideline, my lord. Although, my lord, I'd like to point out that this was not before the Honorable Single Judge, my lord.
Yes,
Page 252, if I may take your lordships to, my lord.
yes.
Page 253, there is a table, my lord. How the CPWD calculates, my lord, when marks are allotted while evaluating bids, my lord.
The CPWD criteria is binding on.
No, I'm not saying it is mandatory, my lord. It's only as a guiding principle, my lord. Lordship sees, my lord, suppose financial strength 20 marks is given. How the evaluation is to be made? 60% marks for minimum eligibility criteria, 100% marks for twice the minimum eligibility criteria or more, and in between 1 and 2 on pro rata basis.
The work, this is construction work.
This is construction work, my lord. What I am on is
This the procurement of service, the security services. and
Security services,
construction
right.
work. How did you?
no, no, requirement is 150 workmen. You are saying that minimum marks is given to someone who is having up to 5,000. So as per the CVC guidelines, my lord, the minimum criteria should be in the next page, page 100, my lord.
Yes.
Although these are also for contract works, my lord. The CVC guidelines is for contract works. How the eligibility criteria is to be fixed? Page 100 clause 5.
Yes.
for civil electrical works, average annual financial turnover during the last 3 years exceeding so and so of the previous financial year should be at least 30% of the estimated cost. So in my respectful submission, madam, if the estimated cost is around 150 crores, at least put the minimum criteria 30 to 50, 40% thereof, and allot the marks accordingly. If that is so, my lord, then I get, I qualify. Here, my lord, the restriction, lordship is correct, that it is minimum is not 5,000, up to 5,000. But up to 5,000, I'm getting only 50% of the marks. A bigger company who has more work power, my lord, he will definitely secure more parts, my lord. Thereby, I am ousted. So my respectful submission is, my lord, this is violation of Article 14, my lord. Because then I take your lordship to the case of Jagdish Mandal, my lord, where in para 20, it has been said that otherwise lordships will not interfere. But if the tender conditions are arbitrary and are made to suit a particular person, then lordships will definitely interfere, my lord. I'll give the citations, my lord. Para 22 of the judgment, Jagdish Mandal is 2007, 14 SCC 517.
2007, 14 SCC.
2017. 2007, madam, sorry, 2007, 14 SCC 517. Para 22.
Yes,
The last sentence reads like this, madam. Therefore, a court, before interfering in tender or contractual matters in exercise of powers of judicial review, should pose to itself the following questions: whether the process adopted or decision made by the authority is mala fide or intended to favor someone. Here, ultimately what has happened, my lord, if I take your lordships to page 241, my lord, only 2 bidders were selected. And both the bidders have quoted the same price.
matter.
Ultimately, no, my lord. Ultimately, the marks obtained in the technical bid decides. Had it been a case that, my lord, whoever has qualified, attained the qualifying marks are eligible, and the technical bid marks have got no role to play. Here, lordship sees both the parties in the middle. Both the parties have quoted the service charges minimum of 3.8%. As per the terms and conditions of the bid, it is quoted, my lord, if more than one agency has quoted the same charges, bidder shall be selected on the basis of maximum marks allotted to the bidder on technical evaluation bid as the sole discretion of the university authority. Therefore, the committee has recommended bidder so-and-so having highest technical score for award of the contract. So ultimately, whoever secures more marks in that evaluation, my lord, gets the contract. So that is why it is of utmost importance. Had it been a case that whoever attains the minimum marks is eligible and the price will decide, because price remains the same, 3.85. Minimum wages is fixed. So that is my respectful submission, my lord. It's restrictive in nature. And just to point out, my lord, at page 110 of the memo of appeal, I have made that averment that members of the petitioner association will not get more than 32 marks. That is part of my additional affidavit. And the minimum score is 70. Page 110. And then the list of private security agencies with licenses in the state of Assam starts from page 119. And I've stated that none of the members of the association will qualify.
Yes, Mr. K.
Total 12 tender were participating in that entire process.
Total?
12.
Yes.
Out of that, lordship, the respondent, private respondent was selected and he was awarded contract. Lordship, now, lordship may come to page 231. Finding of the learned single judge with respect to the paragraph 8 onward.
Yes,
Paragraph 9. As seen, the petitioner is agree with the manner in which the points have been allotted in order to qualify the technical evaluation in tender notice dated so and so, on the ground that same is unlike and the earlier tender notice issued by the university, particularly on 19 to 2018 and 17 to 2023. According to the petitioner, the earlier tender notice for hiring the security service for the university laid down certain terms and conditions enabling the member of the present association participating in the tender process. However, as per the impugned tender notice, it would not be possible for tendering intending tenderers, particularly such member of the petitioner association to complete the tender process. The minimum points or mark required to be scored is 70 in the technical bid evaluation in order to be qualified for the financial bid. From the certain criteria laid down, the petitioner contended that the member will not be able to even score 70 mark points. In view of the issue raised by the petitioner in criteria provided for the technical bid, we may examine the same. It is seen that for the experience in the work concerned, the tenderer would get 10 marks for executing single contract value up to 10 crore during the last 3 financial years and 20 marks for executing single contract value above 10 crores. 5 marks has been fixed for annual turnover for the company up to 100 crore in a year during the last 3 financial year, while 7 marks is fixed for annual turnover between 100 and 200 crores. For those having 5,000 members of manpower on payroll, 5 marks will be given and 10 marks those having above 5,000 numbers manpower. It is therefore, it can be seen that no minimum criteria has been fixed for in order to get the marks under the technical evaluation. For those having criteria of CAPC, which is also no compulsory, 5 marks can be earned. Therefore, from an overall appreciation of the distribution of mark and for its criteria for earning same, one can say that there is no restrictive clause. This court also finds that the CBC guideline issued by the MOM dated 17/12/2022 and also General Financial Rule 2007 cannot be said to have been violated in view of the finding that there is no prohibitory clause in the tender. The PSARA provided for the regulation of the private security agency and grant of license. The grievance made in the instant case by the petitioner is otherwise in respect to criteria for allocating marks.
we have read.
Lordship. So, Lordship, there is no restrictive clause. Everybody can participate. Lordship, learned single judge, while issuing the notice, directed them to participate in the process. But in spite of that, they didn't participate. According to the process, Lordship, the learned single judge held that there is no restrictive clause. And we awarded the contract to private respondent after passing of the order.
Any law?
Lordship, indeed.
Any law on this point?
Lordship, judgment has been quoted by the learned single judge that I am relying on. And recent judgment, Lordship, that it is the prerogative of the employer to decide the criteria. And
Is that
Lordship, I have not brought, I'll supply after some time.
for what you are arguing here?
No, Lordship, that is the law. Recent,
So that is the law, so show us the law.
Lordship, after some time, I'll provide the copy.
This is for final hearing, at least you should bring whatever you have. Order is a
Much.
But regarding, just one more point, Malad, regarding that question, Lordship, whether anyone from the northeastern states is eligible, there is a pleading, Malad, in page 213, Malad. Can I kindly make a note? They made a specific statement that in the entire northeast, Malad, there is not a single tenderer who achieved the qualifying mark. Page 213. Obliged.
Item 9 and 10.
Wait, is a lot.
Yeah.
Well, the issue here was whether the petitioners are entitled to be included in the old pension scheme. They filed a petition. claiming that they should be included within the old pension scheme, not the new. Basic case was that they were appointed in 99 as school teachers, but subsequently in 2005 they were regularized by an order. There was some litigations in between. Therefore, but technically they ought to have challenged that order by which they were denied, saying that we cancel the earlier appointment. That was not put to challenge. So on technical ground, court said sorry. Now, because, my lord, what I find the other day, I got some information from the other side that meanwhile Lordship has also passed some orders in such matters, referring the matter to the government. Government has constituted a committee to look into. On principle, government has accepted that similar to the direction issued by the central government, the persons who were appointed after 2005, but their process of recruitment was initiated prior to, they should be considered and brought to the old pension scheme. And Lordship may kindly see that notification they have issued. One notification from the Joint Secretary to the Government of Assam Finance Establishment, asking the other authorities of the government to consider on the basis of the proceeding, minutes of the proceeding, which was with the Honorable Chief Minister and the Karmasari Parishad. Referring to this, Lordship has also passed an order. I think the purpose will be served if similar order is passed here. Referring the matter to the committee. It is order dated 26/7/2024. Lordship Naramarayan Bosumotari and 28 others. This is the case. Lordships directed in that order, third paragraph from the last bottom.
Yes.
Therefore, similar direction will do. Let them consider if they so decide, notwithstanding the order of the learned single judge. But will make it clear that will not be a hurdle for them to consider. Let them try there. Because I cannot improve anymore now because that has not been challenged here.
That office memorandum which will take into consideration was by the finance department. Here the finance department is not a party. They probably will have to move an application before the finance department to consider their cases also. Otherwise, the stand of the department is clear. So far as the petition or the
These technicalities should not come in the way. Government has already taken. Lordship's direction is enough.
in the absence of the finance
Finance
department.
department cannot have any objection that we are not made party or we will not be bound by. এখন কমিটি কৰা এখন মোক ভেজ লাগিল না তিনিজনীয়া কমিটি এখন নে কি কৰি দিছিলে সেইটো
আমি নাই কৰা, এইটোতো মই নোৱাৰো, এইখন ফাইনেন্স হ'ব।
তুমি মোক এটা কমিটি কৰা এখন তেওঁলোকে কমিটি নেকি?
নাজানো, এইখনে আছে আৰু মাইনর মিটিং এখানে আছে।
No, মই আকৌ এইখন কিবা কমিটি চাব লাগে। কমিটি এখন কমিটি বুলি কৈছা যে
বনাব বুলিয়ে কৈছে গভৰ্ণমেণ্ট উইল কনচিডাৰ ইন মেনেজমেণ্ট গভৰ্ণমেণ্ট উইল কনচিডাৰ ইট উইল
হোৱা নাই।
ফাইনেন্সে কৰিব
সেইটো কাৰণে তেওঁলোকে ডিৰেকশ্যন দিছে
ফাইনেন্সটো লাগিব
লাগে তুমি এইটো ডিৰেকশ্যন প্ৰথম যি কি হ'ল
Talk?
Yes.
What is it?
Public.
Passover meter 3 and 4.
Well, the affidavit has someone record your worship may kindly peruse. Paragraph six,
Just a minute.
paragraph six.
Just
Go to the.
So now you have not been able to provide this land because you have already constructed a wall.
Right.
Okay, we'll ask them that whatever the expense, you have to spend some money in removing that wall and creating a new wall. They will do.
No, my lord,
They
that,
will do it.
Yes.
that is not the question, my lord.
That is the question. यही है wall बना दिया अब हमारा खर्चा हो गया. We'll ask them to pay.
My lord, the security of the, my lord, the petroleum depot and its product and
Security
labor.
of the petroleum depot was very much there in the year 2017 when you made this offer.
Yes.
Today also, only the wall this is concerned. You give us the details, how much money is required for removing that and for constructing new one.
That will
We'll
reduce,
ask them to repay.
that will reduce our area. We have, my lord, asked for acquisition of the minimum where land we require. And
So this was the offer.
no, that
Now
was an
the
offer.
only question is, since we have already constructed a boundary wall covering that passage, we'll ask them to bear the money,
My
the
lord,
expenses, whatever the expenses you are required, you just give us the details, we'll ask them to
My
deposit
lord,
it.
there was an offer at some point of time by some officer, but my lord, now they are not agreeing to it because of the, my lord,
And
safety
then
reasons.
we have to pass an order.
My lord, that is, but before that, my lord, if your lordship, I'll implore that your lordship will hear me on, my lord, the merit of the case because he can.
We'll hear you on the merits of the case,
My-
but it's an offer which was given by you.
That offer does not stand now, my.
And they have not accepted that. But if they are now ready, whatever the expenses in creating the construction of the boundary wall, we'll ask them to reimburse that, all the money. You give us the details, how many, 50 lakhs, 1 crore, 2 crore, you just give us the details, we'll ask them to deposit
My lord,
and then only they'll get the
That
money.
entry is, my lord, the for the petroleum, my lord, the depot, and my lord, the large number of vehicles are, my lord, there. And my lord, that safety is the, my lord, primary concern. No.
Then acquire this land. Is land acquired this
So,
land?
my lord, we have asked for the land we require.
We required and you, now, since we are so much keen about your security and safety, acquire this land also.
No, that acquisition, my lord, that is, we did not require more land than, my lord, bare minimum we asked.
Both the things you can't say.
No, my lord, firstly, your lordship will see, my lord, what is the right of the petitioner that has been violated? I'll come to that, my lord, his
The
prayer in the
right of the
petition.
petitioner violation, his, this piece of land is landlocked.
My lord, if the petitioner, there are two petitions, one petition, my lord, Deepak Damani, my lord, he doesn't have any right, he's asking for easementary right. And so far as Sarada Devi's case is concerned, my lord, if she had any right, that was under, my lord, when the notification under section 141 was issued, and my lord, having not objected at any point of time, my lord, that right has extinguished now. Because, my lord, they did not put any objection, my lord, the land contiguous to their land was acquired, and my lord, they cannot pretend that they did not know when the section 4 notification was issued.
You are adamant. In fact, given the passage, what's the problem? If you have constructed a wall, we'll ask them to reimburse whatever the money is required.
That will narrow our road, my lord. That will narrow our road. If we have to, my lord, give away for 15 feet, that will narrow our road.
Oh, well, this is the side, my lord, not. When the mediator went, at the time, it was the iron gate, my lord. दिया पार्टी को दिया मैं एक टुकड़ा दिया वो तो नहीं है वही तो ये क्या है
When the mediator went there in August 23, at the Iron Gate. Now it appears in front of Iron Gate, they have made some wall, well, nothing but. This is the road only. This is the road. The parking place is behind. Parking, this is not a petrol depot, my lord. This is a parking of the vehicles. There. Behind. On both sides, if you also see on the right side, my lord, there is wall. And on the left side, I don't think that the wall is. This is the present position. Well, yes, on the right side as well, left side, both side. Both. And mediator report made it clear.
My lord.
Okay, the talk is in two places. 1550, maybe there was an offer from the petition also that 350 in one side. She's agreed to give the land from the other plot. But that was not, that did not work out in mediation. Now you have a road which is here. This road comes from the main road to
From the national highway
to the campus.
Yeah.
Now, why don't you give her access to this road?
My lord, the reason being,
Security.
security is the my lord, top, my lord, first suspect.
Mm.
He said, my lord, the land of the petitioner is a huge land.
Mm.
It's not that, my lord, one vehicle will come and 4 or 5 persons will come. Multi-story buildings, many buildings will come there. And there will be hundreds of vehicles and thousands of people coming every day, my lord. That will be, my lord, the contract.
What is the area of the land of the petitioner?
My lord.
What is the area of the land of
Some
the?
5 biggest.
हम लोग एक ना
Number 3, mediation में लिखा हुआ, paragraph number 3. Paragraph number 3 of the mediation.
mediation report.
Mr. Chaudhary, where was that 15 feet land that you wanted to leave? In this map,
This was the, my lord, this, I have shown, they have constructed, my lord, iron gate there.
where?
It was iron gate earlier, my lord, when the mediator visited on 23rd of August 23, it was iron gate.
No, in terms of para 11,
Yes,
that 15 feet wide
yes,
road,
this one,
which is in this, which part?
this one, my lord, both sides,
On the left side.
on the right side as well, left side.
7.5, 7.5.
No, 15 feet, 15 feet. My lord, we have to enter only. We have to go through the road. My lord, it is round by, we have to come back.
So the wall will come inside 15 feet,
No,
both sides.
My lord, this will be, there will be a gate, only we shall enter in there after coming from the national highway. Because this was our path, they have acquired it. So we shall come from the national highway and enter right side and left side. And their parking place is behind.
So near the gate,
Yes,
they will lead 15 feet.
yes. Not,
That 15 feet will come inside.
not necessary, my lord, only opening, there will be a gate. When our vehicle will come, they will open the gate. This is down.
Oh, that will be difficult.
My lord,
But can the gate be brought inside the campus a little bit more?
No, because, my lord, there is other person's lands, my lord. From the national highway, they didn't have any egress or ingress earlier also, before acquisition also.
no, before.
There are other lands.
This
See,
was
you have
our land.
acquired the plot. The acquisition is also of her plot of land.
Yes.
Part of our.
So that is the road.
Yes, no, what, the entire road from the national highway, the entire road was not.
No,
hers.
I don't know. Entire
No, I'm
road was
not
mine.
saying. You have a road. This is the gate.
Yes.
You have a gate here.
Yes,
So that is facing the national highway.
yes,
My lord.
If this gate is brought, say 10 feet inside,
yes,
then they have an access
Yes,
to the
yes.
plot of land.
yes. That can be.
No, within 10 feet, that perhaps that will not be well map on the.
You will be within your property only.
No, my lord, whatever.
Sorry, not the gate.
Map connection to the same file.
उम्र तो मालूम ये हम इसको ठीक ही बोल रहे हैं
No,
मेरे
no,
ख्याल
the
से
map
मुझे
connection no, this is the map. Yes, no, I don't know.
यहाँ पे ऐसा कितना दूरी है लोग तो आते हैं
नहीं, वो अभी
किमान भी होते ये उसको क्यों चुकी तो हम
Same
मैं
two copies.
तो ये vehicle की- ये vehicle की है ना। ये vehicle की है। और ये वो मैं पूछता नहीं पड़ा।
This is the official map. The road, my lord, coming from National Highway, on the left side, the entire plot is not hers. Some other, other owners land.
780 is whose? 780, dark 780. ये পরিগ্রহণ করিব বিদ্যুতের জন্য বিদ্যুৎ Your Doug number, sir?
well dark numbers well they have changed it later on our dark numbers were well 406 407 408 now it is left side well 783 left 783 left left side mediation report the mediation report is later and right hand side well it is 4503 and 784 green color Sardar Devi Damani. Blue is Deepak Damani.
So here, where is the gate? If we look at this, where is the gate?
Malad, that near our land, Malad, they have kept opening because this is the road only. Their parking place is behind.
Where is that gate? In that picture, you have shown a gate. Where is that gate here?
In that, Malad, this is earlier, Malad. Get it. Yeah.
ये अपना-
वो दिन में कहाँ है?
नहीं होता। नहीं, only green. No, that picture was a bit.
My
I
lord,
see.
my lord, in excess of power under Article 226, your lordship may pass any order. But then, my lord, I'd like to satisfy your lordship that, my lord, on the basis of the writ petition, my lord, no relief is can be given to the petitioner. My lord, I want to take your lordship to the prayers in the writ petition.
No,
And the, my lord,
I lie also.
let me complete. You may argue. And my lord, there is nothing wrong in the, my lord, judgment of the honorable single judge. They have come here to, my lord, for establishing some of the right. What is the right that has been violated? And what is the prayer in the writ petition? If your lordship kindly sees the prayer in the, my lord, petition of Sharada Devi Damani, that prayer your lordship will get, my lord, in writ appeal 334 at, my lord, page 57. That is what she wanted in the writ petition. Page 57. Now, my lord, the court at some point of time where, my lord, generous to have some mediation and, my lord, some alternatives, and even, my lord, some officer, which was, my lord, no agreement was executed, my lord, they prepared a MOU, which was not eventually approved by the higher authorities, and that's why this stand is taken. My lord, if your lordship kindly comes to page 57 of the writ petition filed by Sharada Devi Damani. May I read that, my lord? Has your lordship got it, my lord? Please 57 of writ appeal 334.
Yes.
It is therefore prayed that your lordship may be pleased to admit this petition, call for the records, issue a rule in the nature of mandamus upon the respondents to show cause as to why the provisions of right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 should not be invoked in acquiring the land of the petitioner, and further be pleased to cause the acquisition of the land of the petitioner under the Land Acquisition Act 1894. And in fact, my lords, although the land acquisition proceeding was initiated under the 1894 Act, eventually, since it was not complete, my lord, we have paid the compensation under the new Act. So that relief she has already got. Now, these are only, my lord, subsequent developments. There are, my lord, some attempts to resolve the issue. In fact, there is no issue at all, my lord, so far as the writ petition is concerned. And so far as the other writ petition, my lord, he only claimed, my lord, easementary right. For that, my lord, civil court is the base place, or they may approach the authorities, my lord, the deputy commissioner. With this prayer, my lord, I ask myself this question, my lord, how would your lordship like to go into the other aspects? This is the petition in the prayer in the writ petition.
My lord, not only the writ petition, we have filed an IA later on, and there are two orders of the High Court, my lord, for this purpose. They said that they will do it, and they have sent us from their own, my lord, they have sent us a MOU, my lord. That is also there. If your lord,
That's the thing of past.
my lord,
That's the thing of past. That was the thing earlier, not today.
no, my lord, first thing, my lord, they have possibly taken position because no Rojanama has been prepared. A Supreme Court judgment has said,
Sir, you have not challenged the acquisition proceedings as such.
my lord,
You have not challenged the acquisition proceedings as such.
acquisition proceeding, my lord, we
You have not challenged
we have said that it should be passed,
Where
my
is
lord.
that?
my lord.
That
My lord, because we have filed the objections to that effect, my lord, that it should not be acquired. Secondly, my lord, even if suppose acquired, then Rojanama must be prepared, that is to be taken off us by the,
That is
my lord,
the question here.
and it is not a violation of 300A.
Number 334/2022.
हाँ.
Come to the prayer.
तो देखते हैं उसका prayer इसका prayer दो ना yes. Well, so far this petition is concerned, these petitioners' land were not acquired. Deepak Damani.
334.
334, yes.
Yeah,
Oh, sorry, yes, man, 334, yes.
yeah.
They are, my lord, further it towards the proceeding of the land, we say.
Huh?
What's the proceeding, acquisition, what's the acquisition of the land of the petitioner under so and so? Yes, yes.
Simply you said your prayer was so called why the provisions of
Well,
so and so should not be invoked in acquiring the land of the petitioner, further be pleased to cause the
My lord,
acquisition.
at that time, only, my lord, we have no known that later on, my lord, we have filed a petition, page 76, my lord, you'll also see IA.
IL is altogether different, sir.
My lord.
The prayer in the petition.
No, then, my lord, that is why, my lord, this honorable court passed the order. You'll also see at page, my lord, 97, the order was passed. What part is, my lord? Page 97. This is the order of this single judge, my lord. Just C.K. Goswami. Then Justice Suman Sam also passed the order, page 102, my lord. Same line. After acquiring the land, my lord, my land cannot be landlocked. It's a violation of. They have kept the both side path open, my lord, earlier. Thereafter, they have put the iron gate.
It's better you seek a remedy before the civil court.
Well, this is not the, well, your lawsuit will see, my lord, I have already submitted judgments, my lord, regarding section 16.
Yes.
My lord, section 16, my lord, the land, after acquiring the land, it is to be taken over by the deputy commissioner office, my lord.
No road nature to show physical possession taken.
Huh.
This is what 2016, 13 SCC, 2016, 12 SCC.
My lord,
You are relied upon.
section 16, my lord.
Yeah.
And these judgments are there, my lord. 3 judgments are there on the Supreme Court.
Sir, judgments, please show us one judgment. We are again requesting you.
Yes.
Show us the relevant one judgment. Why to multiply the
My
judgment?
lord, first thing, can my land be landlocked, my lord? After acquiring the land, it is not a violation of 300A, my lord.
Ah.
It is a 300A my violation, my lord. My land cannot be landlocked. Either they have to take over the land, entire land, or they have to provide the path, my lord. That cannot be done, my lord, halfway. These other judgments are there, my lord, to that effect.
Other judgment section 4 and 5A,
Yes.
1984, 4 SCC, 2017, 11 SCC. Then
No, so far, section 16 is concerned, my lord, we have given the judgment of from 16. 13 SCC,
2016, 13 SCC,
Yes.
233.
yes,
2016, 12 SCC, 649.
my lord, these are the judgments. And so far, the entire land is concerned, my lord, section 49(2), section 49(2) is there, my lord, as per which, my lord, the entire land can be taken away, my lord. That, on that, my lord, I have given 2 judgments, 75 to SCC and 64 3 SCR, my lord.
Yes, sir.
Either they have to take the entire land or they have to give the path. My lord, page 104, my lord, you'll also see they themselves send the MOU. 104. Initially. So in this item number 4.
Yes.
Page 104 at 105, my lord, this was sent by them. My lord, this is. They say that they will do the same with Sarda Devi Damani only. Sarda Devi mistake, and not Deepak Damani. 107, paragraph 3 and 4.
Yes.
My lord. 107, paragraph 3 and 4. The first party, while constructing boundary wall, bifurcated the land, dark number so and so, on the left side from the main road, one portion of the large so and so, left for 1 and 3, having 25 feet was left by the first party and second party. And for the right, put her own gate on the right side. One way, wide 25 feet each left for the common path. They are permitted to install their own iron gates at their own cost for ingress and egress in future. So this is the MOU, my lord, given, my lord, by them. After the court's order.
That has never been materialized.
No, my lord, they have, initially, my lord, they have agreed, my lord. My lord, my land cannot be landlocked with it. That's a west, my lord. It will be west. That is a violation of 300A. 49, section 49 says, my lord, either they have to take the entire land or, my lord, that is why I relied on judgment, my lord. My lord, so far path is concerned, you will also see, they have, this is the only path. They are, it is their only, my lord, parking depot. Parking depot. Earlier, my lord, the tankers were parked by the side of National Highway. That is why they have acquired it. Now parking place is behind. It is only the path, my lord, by which the vehicles will go. And we were given the path, my lord, originally, that you can go and enter into own land. This was the agreement, my lord. Now, what is difficulty? I do not understand, my lord. There is no question of security also. If necessary, they can put another gate also, my lord, there. In this, after those gates. My lord, that is not the difficulty at all, my lord. As my Justice, my lord, I have submitted that the gate, well, there can be another gate also, my lord. After our entry, my lord. Because our land cannot be landlocked. It is a violation of 300A, my lord.
that was a view from the picture.
Yes.
But that picture and the map is not matching.
And the map.
My lord, if I may point out, my lord, section 49 doesn't relate to land. It relates to, my lord, the building.
No, that, land also, my lord, I have.
That if your worship kindly reach, my lord, section 49, building only.
I've submitted.
And they can, my lord, apply for higher compensation for that.
But my land, my lord, this is violation of direct violation of 300A. Your lordship may just see, my lord.
Yes.
75 QSCC, my lord. Right. Paragraph 6 to 11, my lord. It says for the acquisition of vacant land also it is.
Yes.
Well, paragraph 11, it says, in the present case, the land was not completely vacant, even if there is a vacant land under section 49 of the Act will be affected for the original definition of the land. To exceed the contention on behalf of the appellant, section 49 speaks for acquisition of land along with a building, and not to the case of acquisition of vacant land is the rob of the meaning of the section 49(2) of the Act, and the contents of section 49(2) of the Act. Section 49 of the Act applies in cases acquisition of vacant land along with. Then 64 SCR also, my lord. In 64 SCR, my lord, paragraph 13. Section 2 of section 49 seems to contemplate that where land is acquired, is shown to form part of the house, it would be open to award the owner house of additional compensation under third clause for insurance. So this is going on. Section 16, paragraph 16, second part, my lord. Please. So it is not, my lord, bar, my lord. They have to acquire the entire land, my lord. It cannot be, because otherwise it will waste, my lord.
Yes.
The violation of 300A, my lord, of the Constitution of India. And what they are submitting, my lord, that this parking place is behind, my lord. It is not that, my lord, the parking place is here, my lord. Parking place is behind that. This is only the path.
Yes.
My lord.
That's all. Yes.
I have already pointed out that where in the rectification is different, my lord, and so far the submissions, all the submissions made and subsequently, my lord, I filed, my lord. These are not in pleadings, my lord. In fact, my lord, challenging the acquisition process, my lord, that there is no, my lord, specific pleading why the acquisition was bad. And my lord, so far as the taking a part of her land, my lord, the government affidavit is very clear, my lord. They had published the notification under section 4 and subsequent notifications, and at no point of time, my lord, there was any objection raised. And therefore, that right also, my lord, that has extinguished. My lord, the petitioner appellant cannot, my lord, pretend that she was not aware of any acquisition process going on.
Reserved.
Highly obliged.
Lordship, in respect of read up to 333, Lordship, just I want to submit 2-3 parts, Lordship, in respect of the Ken Chaudhary sir is absent today. So
Which matter here?
read up bill 333.
Yeah.
First one. Yeah, Lordship. Lordship, it is an admitted fact as per the mediation report, Lordship, as per the Honorable the court's order, Honorable Justice B.P. Kotik was engaged as a mediator. the mediation report is just to call, was arranged because of to come to a common conclusion so that the no party should be affected. It's a welfare legislation part. That's it. Here in this case, objection, because technicality doesn't come everywhere when the welfare justice is affected, Lordship. Here in this case, Lordship, their submission, the only basis of the pleading part in the writ appeal of the Sarda Devi Damani comes up. Lordship, on taking 2013, Honorable Justice 27/8/2013, the Honorable Justice Arup Goswami, where they have come up and said that they will try to settle the matter amicably. Accordingly, the mediation process was initiated next day, where both parties seated and asked for 20 to 25 minutes because it is admitted fact that they forcibly acquired the plot and also cheated us. That is mentioned in I also. What happened? We've come to laws, they brought the bulldozer, everything to demolish the wall. Then we 11/11/2020 we lodged a fire. Then work was stopped. Then on 24, they come to an amicable settlement and they wanted to execute the agreement, MOU, with the Sarda Devi Damani alone, Lordship, and giving this MOU. Now they are taking that some of the officers, is it not their burden? If any action has been taken upon that person, here you are causing loss because we have 7 bigger land, you have bifurcated, no possession but through the government was taken over. Technically, their party, something is missing in the petition also, Lordship. In reply, I will place before the Lordship, allow me 5-10 minutes, how the false statement they have made, Lordship, in this case, Lordship. Come up, Lordship, that is important part, how they have in their affidavit, Lordship. Affidavit dijiye na, inka. One May, Lordship, in 2017, they agreed to 15 feet wide road affidavit. Then, Lordship, after 4 years, 2021 also, they said, we are ready to give you 15 feet wide road because this is a common, both sides 15 feet. Then what happened, Lordship? See, today they have filed, they have said that same language, only wall is constructed. Honorable BP Kataki made an effort, Lordship, kindly, so the mediation report is very crucial and very minutely it was decided and leave it to the court whether come to final decision of the court. I want to read this mediation report, kindly. This is very important to go through all this part, kindly. Paragraph number 3, Lordship. Because now they cannot segregate both parts. Otherwise, initially they have to say that part. They both are different. Paragraph number 3.
Yes.
While the entire land measuring 3 kattha 15 lacha covered by dag number 3079 and 18 lacha 757, that is the land of the Sarda Devi. I have given the trace map, Lordship. The green color mark is of land that they have acquired. Only right of way that was there. Belong to Srimata Damani, have been acquired 2 bigha 1 kattha 10 lacha. Out of 7 bigha 4 kattha 9.5 lacha belong to her. Covered by dag number 783 has been acquired, leaving out 5 bigha 2 kattha 19.5 lacha. Because of the acquisition of the land of Srimati Sarda Devi Damani, 5 bigha 2 kattha 9.5 lacha of left out land was bifurcated 2 plots. One on the northern boundary of the acquired land measuring 2 bigha 4 kattha 19.5 lacha, and other side southern boundary of the land acquired 2 bigha 3 kattha. The dag number of the land measuring 2 bigha 3 kattha on the southern boundary of the acquired land remained the same, which is dag number 783. But the new dag number in respect of land with 2 bigha 4 kattha 19.5 lacha belong to Srimati Sarda Devi Damani. On the northern boundary of the acquired land has been allotted, which was 4503. New dag was created without serving any notice. The land measuring 3 bigha 1 kattha 15 lacha covered by the 784 belongs to Deepak Damani and Manak Damani. Is contiguous to the land covered by 4503. Old is 783 on the northern boundary of the acquired land. After acquisition of the land, while dag number 3079757 are maintained, new dag number so and so was created, bifurcated, so was allotted. So in this way, no notice never was come. Honorable Writ Appellate Court by common order dated 10/8/2020 passed in writ petition appeal number so and so for reasons recorded therein referred the matter to mediation for the purpose of making an attempt to resolve the dispute amicably. according mediation proceeding has been conducted. Then Lordship, I will come to paragraph 6, Lordship. Till date, there was no wall, nothing. The mediator conducted altogether 7 mediation sessions, 26/8/2012, 14/10, 6/10, 9/10, 13/3, and 27/10. Minutes of which have been recorded and circulated all concerned. In the first mediation session held on 26/8/2012, all the concerned parties have explained about the role of mediator, which is to make an attempt to facilitate voluntary resolution of the dispute of the parties, to assist all the parties in identifying the issue, to explore the areas of compromise, and to generate options and attempt to resolve the dispute by reducing the misunderstanding, if any, amongst the parties. All the concerned parties have been informed that mediator cannot impose any terms and settlement of the parties, and settlement to be arrived and has been as per their agreement only. The remaining land covered by DAG number 783 and DAG number 4503 and 7 became landlocked due to the acquisition of the IOCL. Field visit was conducted 29/8/2023 from 2 p.m. onwards in presence of the representative of all parties writ appeal. Memorandum of field visit has been prepared and circulated to all concerned parties, which along with the site map prepared by the circle officer, district officer at enclosure A. So the trace map which is given the part that is not drawn by us, that is by the circle officer is given. Marking was given as per the direction of the Honorable Justice, retired Justice, so that court can easily understand. Color was made in that manner only. Then Lordship, issue 9, the mediator having regard to the pleading of the parties in writ appeal, which are made available by the registry of the Honorable Court, including the draft of MOU sent by the officer of the IOCL to Deepak Damani by email dated. This is, Lordship, 24/11/2020, affidavit office filed on 31/7/2020, more particularly the statement made in para 11 thereof by IOCL in WPC, so as well as various orders passed by the Honorable Single Judge in aforementioned writ proceeding and discussed and held in all the parties concerned. In the mediation session number so-and-so, identify the following tentative issue on which attempt to facilitate voluntary resolution of disputes of the parties may be made. 1. Providing the right of way to the land of the appellants in both the writ appeal. In the alternative, to acquire the remaining land of the appellant in writ appeal, measuring 5 biga 2 kattha 10.5 lacha in DAG number 783 of KP Pata number so-and-so. Acquisition land of the appellant in writ appeal number 334, 2 biga 1 kattha 13 lacha 784 of KP Patam so-and-so. After conducting the field visit, the following possibilities to explore the settlement were identified, which were recorded by the memorandum of field visit prepared and circulated to all parties concerned. To have access to the land in DAG number 783 belong to Srimati Sarada Devi Damani. That is the acquisition of land. I shall provide a path of southern side of the acquired land in DAG number 3079 and 757 to make provision a path on the northern side of land comprised DAG number 755 so-and-so. B, to have access to the land of 4503, which is part newly created from 783, belong to Sri Sarada Devi Damani, and land comprised DAG number 784 belong to Deepak Damani and Manik Damani. So these were the given. Now let's come to the paragraph number 13 here. The learned counsel for the writ appellant has informed the mediator that the writ appellants are not agreeable to the aforementioned proposal as recorded by mediation session 27/2023. The IOCL also did not agree to the said proposal. None of the parties have submitted any other proposals which attempt to make settlement of the dispute could be made. And
So whatever the, on 27/10/2023.
Yes, let's.
Whatever the suggestions is given by the mediator, you were not ready to accept that.
Let's see.
No.
Yes.
This is what 27, whether Srimati Meena Dhawani would agreeable to exchange her land measuring about itna with the equal quantum of land acquired for the purpose of making available exclusive right of basis and order boundary of the acquired land number so and so up to 25 wide gate put up by the ingress and egress of the land belonging to Srimati Sharda Devi and Shri Deepak Damani and so, whether it would be agreeable for exchange of such land. The learned concept for the referee informed the mediator referee are not agreeable for the aforesaid proposal recorded, and the IOCL is also not agreeable. So Now you are relying on this.
My lordship.
And when he suggested that you do this, you said, no, we are not agreeing.
We are not agreeable is their statement only.
This is what?
No, ultimately, in mediation part, lordship, there is no question of that. We are the deprived persons, lordship. Last to the nothing, no mediation.
This is what paragraph number 13. Read.
Paragraph 13 of lordship.
Mediation report.
The access to land comprised of Dagdama Seventy Four is presently given to IOCL.
Paragraph number 13, sir.
Paragraph
The
number-
landed council for the writ appellants inform the mediator that the writ appellants are not agreeable to the aforesaid proposal recorded in mediation session. Itna.
Interesting.
1-3,
Lordship, coming to that part.
page number 6.
The learned counsel for the writ appellants has informed the mediator that writ appellants are not agreeable to the aforementioned proposal as recorded in mediation session 27/10/2023. Also, IOCL did not agree to the said proposal. None of the parties have also submitted any other proposal on which attempt to make settlement of the dispute could be made. Then the mediator does also advise the parties to make effort to settlement of their dispute, identifying the issue. Now, lordship, that is the said by the mediator, you both parties settle. But the thing is that that was not come into conclusion. Because one thing is clear, my land, only 2 bighas they have acquired, 5 land is left on left side. I need the way only. That is only my prayer, only way. Right of way only, nothing else. And lordship, in their MOU, they agreed to that part. I will not go to that technically. Why I said deny to that? There is no question of denial. 7 bighas land, 2 bighas only acquire. Left side land is lying, other right side land is lying. Only right of way I am seeking only, nothing else. And as such, the 2020 MOU was executed from their side sent, where they wanted to execute with the Sarda Devi Damani. Can you see? But is the question comes that I want to deny that part. Because they do not want to sit together. Not a single day any officer appeared before the mediation proceeding.
Yes.
Look, about the thing I'm trying to read. Okay, Lordship, one thing also here. Hey, it was- This report, we submitted before the mediator. Because time to time, any proposal, any type of, because effort, every effort was made. And here, this, we have submitted. The Lordship, that we want
Your
to
land
settle
is
the
not-
matter
Your land is not adjacent to the IUCN acquired land.
through
In
Sarda
which
Devi
Sha-
Damani, through Sarda Devi
Sharda
Damani.
Devi's land.
So we filed a writ petition against the Sarda Devi, making her respondent number 8, because for herself, we purchased the land, only right of sea that in future she should not disturb in the entry or egress. That is about 3 to 4 bigger land loss. Now we also wanted to settle them, just try to off the court, we also approach
You have
and
no
get a
direct conflict with the IUCN.
no direct opinion, but whenever as the matter was taken up, they filed affidavit to give right of way to Deepak Damani. That is commonly. Or here, Lordship, if you process this, sir, here in page number 13, Lordship, we submitted this and copy was served to them. From their side, nothing was come up. That is here in affidavit have come up, affidavit what they have submitted, landlocked they admitted. This is landlocked. If suppose today they are coming to the writ petition and seeing only the pleading part, only that is technically. Why this so many years they've taken? They should stand on one point. They themselves filed affidavit. Both the cases are taken up together. Court has made every attempt. Because no one can restrain the right of entry. And they agreed. MOU, they have executed. Now say that any officers earlier, they did it and we denied. Where is the denial? I am giving all the evidentiary value before document before the court. That we approach. I personally, along with the appellant, approach. Because mail was sent to me also, Sarma.Biswambar. How can they deny that MOU? But that time they wanted to execute with the Sarda Devi Damani. Today they have come to the pleading part only prayer portion. No relief is sought for. That cannot be. Arup Goswami also tried, they themselves come up that they are agreed to give the right of way, they want to settle the matter amicably. Every attempt, so many dates were taken up. Now that is only the parking ad, nothing happened. If that is happened, they would have stand in the same point. In 2017, they are taking the 15 feet wide road. 2020, they too then that have happened. If they stand with their own point only, though this is for security purpose, they would have a stand. They cannot change their stand. Then 2020, they agreed to execute the MOU. Because if anything falls, I'm liable to face the prosecution. They sent the mail. Then they wanted to, because what happened? They arranged the road. Hence, my senior counsel read the paragraph number 3-4. They what happened? Both sides they left 25 feet. Egress, they have 25 feet. And from main road, they wanted it a common road. So install our gate also, their gate also, in one point at one point of time. So the person move to their side. No parking will be taken by the petitioner side, appellant side. So everything was agreed. Everything agreed. Now, when the matter has to be, because as Deepak Damani has also in the writ petition, so he should be the party. He should be the party. Therefore, no reply. Can you say? No, nothing. Only verbal part. It is very difficult to meet the officer every time. We are like a beggar. We approached there. I personally went there. I stood about 2-3 hours there. I requested, like begging, because my land has gone. Money has not been paid. Deposited because litigation pending. Last 2012-13, they said that 2015, 2020, paper published 2015, that is there. 2020, 11/11/2000, we lodged FIR. That time, they said that they will come and amicably settled. So at least allow us to enter. That is written in the FIR. We are already allowed on that day. When bulldozer, I have given the photocopy of photo also of that. They started damaging the wall, everything. Then we lodge FIR. Then they again called us 24/11/2024. Called us called us that they want to execute the MOU. If this is so, can they take display on the writ of single line of petition? They are praying the fair justice. What is the effort of mediation? On that day, they have to say before the court, no, we are not agree, we will not go for mediation. We are not ready. Party has paid huge fees to everything, everywhere. Now begging, and the photograph is taken from the outside. From others' building, the photograph was taken. And can you see the wall? They have processed 25-feet wall later on. Not from the beginning. 2024 later on, they have just wall, not painted. And behind that, there's an iron gate also. 25 feet iron gate on both sides is there. At least that is to be considered. It is to be given. There is no harm to them.
Order is that.
Obliged.
Hello.